If an artificial intelligence creates a piece of art that looks just like a Basquiat original, who owns it? That is one of the core questions being debated as AI-powered artwork floods the internet. We got these images from DALL-E 2, one of dozens, if not hundreds, of AI image generators. Here's how it works. AI programs are fed pieces of existing artwork to learn how to draw. But sometimes the AI is trained without the artist's permission. For more, I'm joined by Bradley Hulbert. He's the founding partner of McDonnell, Bowen, Hulbert and Bergdorf, LLP, an intellectual property law firm. Brad, in your legal opinion, if artificial intelligence creates an image, who owns it?
It depends. The law is playing catch-up with the new technology, and so it depends. But the law says if you create something, a work of authorship, you own it. If you take someone else's copyrighted material and you add to it, then there's two copyrights on it: the original author and then what the second author who's added to it. So it depends. The Copyright Office, though, has also said that only humans can be authors to get a copyright. So it's unclear at this point. The law is changing.
DALL-E, we got in touch with DALL-E, and they gave us this statement. They said, DALL-E produces unique original images that have never existed before. When DALL-E is used as a tool that assists human creativity, we believe that the images are copyrightable. Users own the images they create with DALL-E, and by extension, any copyright. So does that sound within the scope of what you just described, or is that general and the devil is in the details?
The devil's in the details, absolutely. The training process for DALL-E 2 and other machine learning programs involves looking at thousands or millions of pictures and then sort of learning, as you suggested, what a particular image should look like or what it can look like. If sometimes, though, the machine will turn out an image that is very close to something that it learned. And it turns out, well, they're substantially similar. And that turns out to be then copyright infringement, because you are making a work, you had access to an original work, and the thing you are generating is substantially similar. And that's the general test for copyright infringement, in lieu of someone admitting they copied.
And if substantially similar, is that standard by kind of a reasonable person's view? In other words, if I saw something that looked just like a Banksy that I've seen, and in fact it was created by AI, is that the test? Who's the judge in this case of what's a reasonable imitation?
Well, if either side requests the jury is the determiner of what is substantially similar. And it's been called the troublesome doctrine. It is inherently ambiguous as to what substantially similar means. And the different federal courts throughout the country have different rules for applying that ambiguous test. So it has to vary, because if there's two pictures of a Civil War battle and they both have horses and men in uniform and bayonets, well, okay, those similarities don't mean it was copied. But if General Lee is riding an orange horse in both pictures, well, chances are that was copied. So the devil's in the details, as you say.
Let me see if I can mix the spaghetti and the sauce a little bit more here. Let's say it's an image of a person, say me, and someone has created an AI piece of art in a particular style of me, and maybe it's not flattering. So who's got control of the image? The person who created the AI, me, or the person in whose style the AI has been created?
You raise the doctrine of fair use. If I change it enough, if I transform it, then it is a new piece of authorship, and the piece that it formed the inspiration for it does not have copyright in it. It's how much did you transform it? So if National Lampoon did Board of the Rings, that book, it stole no sales from Tolkien's Lord of the Rings. It's a completely different approach, different message, not copyright infringement. But the movie Lord of the Rings, in fact, was a derivative work, and that you'd have the the producers of those movies had to get a license because it was derivation.
And so finally, quickly, is that what's at issue in the Supreme Court case over the transformation of that picture, the photograph of Prince by Andy Warhol?
Right. It was argued last October. Absolutely. Was it transformative? Is the message substantially different? And again, it's a frustratingly ambiguous standard. Was it transforming of what the original photograph was like? And it's up to the jury. You bet.
Okay. Brad, thank you so much for being with us. We may talk to you again unless I'm replaced by artificial intelligence by then.